Okay, abusia mama kwaba sonko so ba POG Media so yes so say ene dey count dwumade a obe subscribe no like it no share dwumade so ama afofon so ensa etumi aka bi, and do not forget to click on the notification bell so say na be ya any update be bia no wonso wonsa etumi aka bi. Abusia yensem brepi no yemanwa yensem wa ye de somo eye one of the Ghana biggest politician now so power ye pa aba out at the suggestion about Ken Ofori delays about the extradition no. Now chiremu asisi no the only option na e betimama Ken Ofori sanso aba back to Ghana near demonstration na e was say yekoye no US embassy no. Ebutu okan sempi yenko ne yenko tie ensemu a odi tuda.
Look, at a point after Kissie Ejabin is left, later in our series to get justice, we may have to organize a demonstration to go to the US embassy and present a petition. That's what we have to do. We have to mobilize Ghanaians after Kissie Ejabin is left, because that's the first point. We can't trust Kissie Ejabin to do this work because he saw Ofori leave. He saw the letter. I'm happy Professor Jampo is here. Please, Mr. Okansi, when he gets to his side, let him explain the political theory of the state. How, when I keep saying, when I quote the constitutional provisions and I show that under the constitution, Kissie Ejabin had a mandatory duty to inform Ghanaians once he saw Ofori was leaving, and he alleges that the other.
So you expect that you address a press conference?
Exactly. So I want Professor Jampo from the governance experts to come. And also, no, there's also governance. Let all the governance experts weigh in. Then we see that it's a serious constitutional matter.
You see,
serious
in this instance, I'll come to you.
Okay.
I'm sorry. But his lawyers are saying that he has not been formally served.
So that's why we said on Monday we'll hear that. So let me just read it. That's why I said cogent evidence how he's been served. 19.3. Just for those who want to hear the constitutional words, then we'll move on. It says the trial of a person charged with a criminal offense shall take place in his presence unless A, he refuses to appear before the court for the trial to be conducted in his presence after he has been duly notified of the trial. So after he has been duly notified. So Monday we'll see, maybe if OSP did it and has not told us yet, well, Monday we'll see. You see, but the key point we're making is that the extradition itself, look, it's not a joke. It's a whole process. That's how come I said after we get Kissie Ejabin out, we'll have to mobilize Ghanaians. Once the US government understands that citizens understand what's going on, that extradition is political, maybe it will help them to bring Ofori. But if we leave it to TV analysis, you know, they also gauge public opinion. If a few experts come and sit here and say extradition, and then lots of our citizens are not bothered, it won't happen today. But when we mass up a lawful demonstration quietly to the US embassy and present a petition that we want the American government to bring down Ofori, it would help.
So that extradition process is what I reserve that for lawyer Christian Mamhesi because he's written quite extensively on it. So I'll come to you on it. But don't be Apiakobi.
Right. In fact, I'm a little worried about the whole process because I've heard of lawyers of Mr. Ofori also writing to OSP and responses coming and publications thereof. And I asked the question, upon what information is lawyers writing to the OSP? Is it the case that OSP has served Ofori a process for which reason they are responding and even suggesting dates of his arrival and his interrogation? Is that the case? It's another big question we have to answer. If there was no such correspondence or information, lawyers will ordinarily not act without instructions. So the presumption is that Mr. Ofori has knowledge of any such invitation and has instructed his lawyers to respond. Otherwise, the lawyers would not, out of the blue, just come out and respond. And your relationship with your client is not in perpetuity for you to say that once I hear that my client, you have mentioned my name, I write. No. In all situations, you must take instructions from your client because when he is even your client on retainership basis, something new comes, you need to inform him and then take instructions. in relation to that which would have come to the fore. So I'm worried. I don't understand why lawyers will respond if he has not been informed of anything. And the reduction from public view doesn't connote withdrawal of his name from the shadow of Interpol.
So
It says that it is only the public who cannot see.
But he's still
It is
on the
not
list.
by way of publication. But the request from OSP is still there, probably with his name and documents attached. But it is that for the purpose of Mr. Furiata's complaint of service, they want to investigate how authentic the application is. And indeed, service does not connote hearing from the public. So if I'm coming here and you have sent me the process and you are talking about it even on your platform, that does not connote service. And indeed, for criminal proceedings of that nature, you must serve the person, not
That is, that you must serve the
that
person,
person,
physically.
the
You must give
suspect.
it
You
to
must
him.
serve him. Only to say that if you are not able to serve him personally, there are other means of service, genuine service, substituted service. You go to the courts and find the court's orders, and the court will order you how to effectively serve that person. Circumstances will determine. Again, non-service. When you don't serve a party, a process, you don't start anything. So I'm worried, why will the Interpol place him on red alert when there is so probably evidence of non-service? So I'm also worried.
So that's why, you see, because we talk about the availability of new information, a review process that's ongoing.
Right.
And
so,
reason why,
So I want to believe that Interpol was convinced of this primary requirement of service. That is why he was so advertised. If that is not the situation, then I'm worried about that informality. So,
but then again, does it mean, and this is what people said earlier, does it mean that if, for instance, if he is seen today, he cannot be arrested?
yes, because from the records and from what the lawyer is saying, he has not been officially notified, means he has not been served. And what the lawyers are also saying is that if he has not been served, then he's not ready for any. And again, he says that he will return once he's officially notified. And I'm saying that the notification must be official. I mean, that is the requirement of the law. But when OSP also says that I saw him leave, I couldn't arrest him. OSP has police powers as per his law. Yeah. So OSP can arrest. So if OSP, yes, if OSP didn't arrest him, he has to explain why he didn't arrest him. And in any case, if OSP also wanted to formalize the arrest, he could have gone for an absconding warrant, which would have been served to the border security agencies for them to even effect the arrest. So complaining of inability to arrest, for me, it doesn't stand with me. He had all the powers and all the opportunities to effect the arrest. It was by his decision not to arrest that he was not arrested. So Furiata didn't do anything by going through the process and getting out of the country. We cannot charge him. The person who was supposed to have done the thing also, if he decided not to do it, that he has the explanation.
Well, he's explained why. He said he didn't have the cooperation of the other state agencies.
But he himself didn't need any cooperation. He himself, if I'm suspected of having done something that requires my arrest, he himself is vested in enough powers. In fact, most of these laws, when they were crafted, I was part of the discussion. So even the Yoko boss and his deputy, they have powers of arrest under the Police Service Act. Because they have police powers. It is only the Gold Board that the power was limited to interrogation and searching. There was a reason to do that. So Gold Board has no power to arrest because law board has not been vested with the totality of the police mandate. It is limited. If you go to go boards, as you see that there is limitation in the powers as given to them. Now, the confiscation of property. In fact, as Martin says, the Act allows for trial in absentia. But it cannot start when you have not done this basic requirement of service. So it is so important because once you have not served him formally, and I want to believe that the lawyers' reliance and insistence on formal service is coming out of their knowledge of not being served formally. And therefore,
abusuafo family no na muguso amohwe no abusua e be so subscribe ya be subscribe no one like it no one share dwumadi ama afofo so ensan etumi akabi abusua wo family no okọ so aka ensem pi yenko ne enkotie ensem wo de tuda.
They are also picking information probably from the media, which I think is also not right on their side. I would not write to OSP upon what I know from the media if my client has not been officially served. I would not do that. So I don't think that it was in anybody's business to attempt to respond to any invitations if you have not been served. And the media is not a proper place to serve an accused person or a suspect. Now, on the trial, once they are served properly, formally, and I have also discussed service by substitution. So if for anything at all we can't find a person, please go for substitution and serve him. Once he is served formally, then the trial can commence in absentia. The only thing that, in fact, this one, I know that I had extensive debate with my leadership at the time when we were discussing this act, that we should have, the court should have opportunity to bring our orders of confiscation in the absence of the accused person. And my leadership at the time, they debated me thoroughly. I said, no, he shall be, he must be in the court. I said, look, if he steps out, and for any reason steps out, then you undermine the power of the court to confiscate. Somebody said, go and sit down. How long have you been here? And I said, oh, me, I'm a practical person. I'm a practicing lawyer. And I'm saying that if the accused person manages to step out, it becomes difficult. So all the work done will be cost-empty. And this is in the law now. You need his presence in court for the court to be able to confiscate. It is in the law. You go check it.
That's
you go check
let me
it.
see.
Because there was extensive debate on this, because I was insisting that let the court have the power to pronounce it even in your absence. But we succumb to the seniority power.
No, but when it's trying absentia, once it doesn't come, this one cannot override the constitutional provision.
I'm saying that you
cannot.
Look at confiscation of abscess in absentia. Look at it. Isn't there? I mean, it generated a lot of fury.
And so that would be bad.
Yes.
The judge will not be tied down. The judge will override
You
it.
understand? If the law says the courts are servants of legislation, so if the legislation is served on the court that allow Professor Jampo to go,
does not have discretion.
The court doesn't have discretion, but to allow Professor Jampo to go. So sometimes experiences in the legislature is important, but also as a junior's experience is also important. So this is where we are. We come to a crossroad where the court probably, after a trial, may pronounce guilt or anything. I'm not suggesting that. That when it is so pronounced, then we go into how do we go for remedies as a state. And that is where we are going to probably encounter some difficulties.
I see loopholes. I was telling you, I will to be outstanding. No, section 50.
Your attack should not go to the man OSP. It must go to the law as enacted by Parliament. And these are some of the amendments that could be recommended. But I am telling you from a practical, personal experience that it got me into. I will mention the name too.
Let's look at the section. Otherwise, it will create problem. Let me look at section 50.
I need to move on.
The conditions for the confiscation. And please, let's just make this small distinction. While the trial is going on, what we do is called freezing. So for the freezing, once they file the charges, OSP in itself can freeze for 14 days. But at the end of 14 days, the powers elapse. So he goes to court to get a court order to continue confirmation. So that's freezing.
Is different.
Yes, that's what I say. So now confiscation is when the person has lost, that the accused has been convicted. They want to. So the difference is that confiscation, we take it permanently.
And even with freezing, upon time, a year or thereafter, it lapses.
Yeah,
so freezing is different from confiscation.
The Anti-Money Laundering Act, we've amended, and the OSP one too is not tied down like that.
So I am saying that when it comes to confiscation, that's where we are going to.
So can we look at this? We say that.
But Martin, if you allow me to finish,
No, okay.
I think you take your time to read. Now,
round it up for me.
Beyond confiscation, then we go into the extradition processes. And as Martin says, it's another process of its own that has to be initiated by the Attorney General from here, and then applications filed in the US. And the process will go to the very end upon determination. If the answer is extradition, then the US government will send him. Martin said it's a political decision. It's not only political, it's political and legal. So the legal process will generate a decision, and it will be left with the political establishment to implement. So when we are able to secure the determination in the courts, then you are confronted with an implementation system which is also political.
Let's correct something. Before even they decide to go, it's like prosecution. They can say they won't even go. That's where the political element is huge. It's not after if the judge determines and they refuse, they will get trouble. So they may well decide not to go. They will assess the whole file and say they won't go to court at all.
You see, the whole process will start from the government prosecutor in the US.
Exactly. So you say I will go.
This same concept of nolli prosequa is also applicable to them. They formulated it. So if the state of the United States says that, well, this case is not prosecutable and therefore I won't prosecute, that's another challenge we will face. But if the Attorney General in the United States agrees that we must commence an action, it's an action by the state. And therefore we go through the whole process. And when you finish, the implementation also goes back to politics. So it is not an easy direction to take. But it is also worth taking. For nothing at all, it provides avenue for learning.
Indeed. Well, Professor Jampo, you see, because this matter has both the legal and the governance side of things.
Let me do one thing. Just 1 second. I've seen
seconds.
a practical case, a trial in absentia. The guy went. After that, they confiscated. The properties were just sold recently. Currently, we are chasing for the certificate of purchase. The guy ran away. The court finished and confiscated.
It depends on.
And they've sold the property.
But I'm telling you that if you check the law,
thank you very much.
He must be in the court.
You have different positions on this. The OSP has been clear on why it was unable to do what two lawyers are asking he should have done. And to the effect, 78 charges of corruption and corruption-related offenses have been slapped on Ofori and then also some 6 other persons, all in this matter that the OSP is investigating. He's still out of the country, by the way. His lawyers state he has not been formally served. Could anything have been done differently?
You see, Alfred, I am a bit worried listening to Martin and some other lawyers. It appears it's going to be a very Herculean task to bring Mr. Ofori to Ghana to stand trial in person, looking at the processes that would have to be resorted to. It's going to be very laborious. It's going to be very difficult because don't forget, he also has lawyers. And so they will be fighting what the state would, the measures and the efforts that the state will be putting in place. And that is why I believe, Martin, you've done well. When we started doing public discourse in media, you were not part, but you've come, I think you've carved a niche for yourself. I think I like the argument, the bits that you brought in, that then the OSP should have At a point in time when he realized that he was helpless, I mean, he himself said he was helpless. I called NIB, they were not minding me. I called this one, they won't pick my calls and all that. So I'm saying, maybe, you see, he should have prevented, first of all, he should have prevented the flight or exit of Ken Ofori-Atta. Oftentimes, when people are given mandates, okay, they settle in, and if you don't really sit down to read about your own mandate, there are certain things you may not be aware of. And so I see you, I look at my act, and I know what I'm supposed to do. I don't know whether the OSP didn't know that they have the power to arrest. I don't know. I said, I don't know whether they didn't know. And the other bit is that, well, so that's what I'm saying, that you have to socialize yourself effectively in your own act. Okay, because
for yɛda mo asɛm agye atena se etie ensɛm a yɛde bɛso mo yɛbɛsrɛ sɛ unsubscribe ya subscribe no like no share dwumadi nso ama afoforo nso ensa etumi aka bi, and do not forget to click on the notification bell so say na be ya any update bi be drop bia no won so ensa ebetumi aka bi kan nu say POG ha de yɛde ensɛmpa enkwara na brewo